The last piece of legislation we'll consider is the Residential Apartment Buildings Compliance and Enforcement Powers. So in terms of the first legislation, deals with active registration, compliance and enforcement, and sets out a framework for recovery and a duty of care owed to landowners. The Residential Apartment Buildings Enforcement Act really makes provision for active involvement of the inspectors at an early stage, well before the completion of the building, to investigate serious defects and take various action, which will include compliance issues, investigations and entry on premises and rectification orders. The Act specifically applies to breach of major defects, so serious defects. We're talking about building products or building elements, or where those defects render the building unable or unfit to be occupied, or where there's a threat of collapse. So again, adopting the legislation in the Home Building Act in terms of what a building element is, in terms of the Design Practitioners Act, in terms of understanding what a serious defect is, it's got to be serious. The duty is owed by a developer. That is spelled out to be a person that is the owner of the land. Can also be a principal contractor, where you have more than one contractor that's responsible for the building work itself. Building work is set out in the Act, but will also include design work. The Act will only apply to residential apartment buildings, Class 2 buildings, but it also will allow or permit an investigation going back 10 years, whether or not the building has received a construction certificate or a complying development certificate. So this is the real killer with this Act, that enables active enforcement and investigation by the Department of Customer Service to investigate building defects. The Act also makes provision for another key issue, which will allow the department to prevent or revoke the issue of an occupation certificate and or the registration of a strata plan. Now, we said earlier that part of the problem with the industry in New South Wales and Australia has been that typically after the sale of the plan of buildings, the building is sold after the issue of the occupation certificate. At that point, after the money is guaranteed or collected, the developer suddenly disappears. What this Act then seeks to do is to stop that, to say that before the issue of an occupation certificate, the developer or builder will need to apply to the department for an issue of an occupation certificate. They will need to do that at least 6 months before they are asking the occupation certificate to be granted. This will permit this investigation by the department to understand whether there's the building works have been carried out. It will also prevent, as I said, the registration of the strata plan. Now, if the department finds out or makes an assessment based on its investigations that the work has not been completed in accordance with the relevant standards, it can issue an order which mandates that those the work to be done, what we call a remedial rectification order. The span of that order will be until the work is done, and or the passage of 12 months after the issue of the order. It will also permit the work to be done by the department if, for example, the developer, having received the notice, does not comply with the order. The Act also sets out a system of framework of natural justice. So that will permit a developer to contest the findings of a remedial order or investigations. And those appeals will have to be lodged within 30 days of the issue of an order. They can be contested by the developer through the Land and Environment Court. So this piece of legislation, while I'm giving it less coverage today in terms of time, it's no less an important piece of legislation because of its potentially retrospective nature in terms of permitting investigations for work which have been already completed, whether or not the construction certificate and or compliant development certificate has been issued. It will also mean that we have a rectification order. As I said, it may permit, it will be allow the department to place notice of that order to a certifier, to a local council, and or to the Registrar General. The significance of those developments is that a potential purchaser is enabled through its solicitor or conveyancer pre-settlement to understand whether a rectification order has been issued and complied with. And if that has not been done, then I would imagine a careful purchaser would probably not complete or would do so on terms which required the work to be done before settlement. Again, I think that's a key part of the legislation in terms of providing active enforcement, active investigation, and a signpost to potential purchasers that there may be issues with the building that has been maybe purchased.